My name is Jonathan Prideaux. I've been working in the legal technology industry for not quite as long as Beth, about 23 years now. Firstly with Minter Ellison lawyers, but for the last 19 years with Clayton Utz lawyers. And I'm now the National Manager of the Legal Technology Services Group in that firm. What I'd like to talk about is quite a specific, what might seem a very narrow topic, but one that I'm certainly passionate about, and one where I believe there's a great opportunity for us to improve the delivery of litigation services specifically across the legal industry. And that is the efficient management of documents throughout the litigation life cycle and the corresponding deployment of appropriate technology to support those associated processes. It was great to hear Warwick Soden earlier today, and also I heard him talk, Warwick being the CEO of the Federal Court, speaking at a conference last week and talking about the extension of the court's ECF electronic filing project, with now the ultimate goal of having all hearings or courtrooms run electronically. I think if this goal is going to be achieved, then it's really important to connect the standards that we now regularly employ in the discovery process and the electronic court process with the bit in the middle, the meat and sandwich, if you like, which is the preparation of evidence. These sort of standards and processes already exist. What we've got to do is just have them adopted more widely, I think. The cost of litigation is often criticised, and in particular the cost of discovery is criticised and scrutinised. My guess is, from my observations, the cost of discovery and litigation makes up about 20% of the cost, the overall cost. So it sort of follows that if we're looking for efficiencies and cost savings, well, let's also look at the other 80%, and that is the preparation of evidence, the preparation for trial, and then trial itself. The effectiveness of discovery has also fallen into question. The Federal Court and the New South Wales Supreme Court all have issued practice notes that dictate that there will be no discovery before evidence in an attempt to try and save money, if you like. In reality, what I've seen is there's been no reduction in that collection, analysis, review of documentation. It still goes on for the purpose of case preparation. I think one of the important points is that discovery and evidence prep and then trial and any subsequent appeal processes, they're not discrete. They're intrinsically linked and documents and data flow throughout those processes. And therefore, the efficiency of the management of the data through those processes is going to impact on the ultimate cost. In the Federal Court Practice Note CM6 that governs the exchange of documentation through discovery, it's there to really apply standards that level the playing field so that when we exchange data as a recipient, we don't have to spend more money or do any work with it in order to be able to work with it, analyse it, review it, and so on. So one of the underlying principles that assists that is the idea of unique document numbering. Giving a document a unique ID removes any confusion when it's referred to about what document is it we're referring to, where did it come from, and whether you use that in a list or in a piece of evidence or in any other area. I think that it's a really key principle. What happens often, though, in reality is that a uniquely numbered document is taken out of context, it's given a new number, a new reference multiple times if it's annexed or exhibited to a statement, if it's used in a court book, if it's used in a submission, and all of that work in renumbering and changing the format of a document actually takes time and creates confusion and then creates more work sort of as we go along the process. Documents are often renumbered in a tender bundle, as Warwick said earlier. We have this fixation with chronological ordering and then sequential numbering of documents. So they then get another number, and again, there's more work to cross-reference that goes on in the background. And all of this sort of work kind of takes time and costs money and creates confusion. In an electronic environment, all you've got to do is push a button, and if you want your documents in chronological order, it happens sort of at an instant. So it really does seem to be unnecessary. Counsel and judges also, they prefer a unique tender bundle. But if we've taken a set of documents and duplicated them for the purpose of preparing evidence, it then gets really hard to actually get back to a unique court book or a unique tender bundle by the time we get to trial. The systems that we have, or the systems that exist today, and the way in which evidence is prepared today, they certainly may have been appropriate and inconsequential when it comes to cost, in the pre-electronic days. I'm sure that the standards for annexing, exhibiting, tabbing documents to witness statements, lay evidence, expert evidence were invented 40, 50 years ago, at least, if not before the days where we had this proliferation of electronic data, both by volume and by type. And we didn't have, the tools that we have these days to manage those documents. So I think we really need to take a look at these sort of systems that we use now and really rethink them. In my view, there's no need to renumber a document once it's been discovered and given a number, if you then refer to it in evidence. And by using a unique ID, we can apply tools that can help sort of automatically check that referencing is correct, that it's accurate, it's the right document, and cross-reference and keep track of the document and where that's been used throughout the litigation lifecycle. If matters then go to appeal, then the evidence used in the original tender bundle may well be used in the appeal documentation. So as such, preserving and collating and threading the fast recall of evidence is an essential cost-saving efficiency, I think. So the introduction of a legal profession-wide and whole of litigation lifecycle-wide electronic document management protocol will automate a number of time-consuming and manual handling requirements of these legacy paper sort of processes for evidence and court books, including sorting documents chronologically. A consistent electronic document management protocol will drive down the costs born out of inefficiencies in double handling and significantly reduce the potential for human error. Inefficient work practices, including constant renumbering, reliance on manual handling and printing of electronic documents multiple times, means that cost savings that can be afforded due to the use of technology are not being fully realised in the litigation process and in litigation matters. So while we talk about technology and everyone focuses on the artificial intelligence and the really high-end sort of exciting, media-worthy sort of stuff, I think what we need to do is sort of take a step back and really look at the processes that we deploy in managing information and the volumes of information through the litigation lifecycle these days. The technology is there to underpin a good process and a standard process and an efficient process. The technology itself shouldn't drive the process. And I think that as a profession, if we're to get to where Warwick and the Federal Court are trying to get to, which is a paperless system, an efficient system and fully electronic courtrooms, we all need to sort of embrace a bit of change and really understand what a good standard process can do and then underpin that with the right technology.
At the moment, do you see lawyers and paralegals still playing a significant role in the discovery process? Or are you saying that, let me ask you that question.
Yeah. Yes, we do. We do. And we use technology to assist that process. I think the technology has allowed that sort of work to be driven down from more senior to more junior levels. So we still see that sort of work being done by paralegals, but what I've witnessed in my career is that driving down. What used to be done by the higher level can now be done with the assistance of technology, whether it's predictive coding or clustering or concept searching, and is being done at much lower levels by more tech-savvy individuals, to be honest, as well as some of that work then being sort of pushed out of the law firms and over to LPOs and alternative resources like that.
Is that happening a lot?
Is that happening a lot, being sent out offshore to be processed?
Not as much as I think we all expected. LPOs were a bit of a buzzword a few years ago, and a lot of corporate clients sort of pushed their law firms to use LPOs. LPOs certainly have a place. They certainly are being used more and more, and they're certainly very good at what they do. but it's probably not as common practice as you might think. LPOs are like every other sort of tool in the industry. They suit certain matters, whether it's by volume or by the nature of the information that's being reviewed. And I think they should be used in combination with the legal skills of the domestic law firms as well, rather than a complete alternative. I think that's the intelligent way to use them.
I think the premise of your comments was that post-discovery, but up to and including the trial, the processes that are in place are still processes that were used many, many years ago, and need to adapt in order to improve the way in which litigation is being conducted and the cost associated. Is that correct?
That's exactly the point I was trying to make, that we have some very good standards around the way we review and produce documents for discovery. There are some standards in place for the way e-trials are run. But if we had the bit in the middle, which is to continue to use consistent referencing and good standards for the preparation of lay expert evidence and any other sort of court documents, and the way that they then refer to contemporaneous material or other material, what we'll find is you'll get a lot more efficiency. A standard process that can be learned by lawyers across firms and across the profession will make them more efficient themselves. And it will allow the better use and a more efficient use and a much more cost-effective use of an e-court environment, because if your discovery and your evidence preparation is done in a standard way, then the information that makes up the court book, it pretty much creates itself. It's automatically generated and can slip into an e-court environment without too much additional cost and processing. What we currently do or have done in the past is a lot of reprocessing and renumbering, reformatting at each stage in the process. And with the tools that we have these days, that sort of work just simply isn't necessary.
Is that duplication driven by a lack of cooperation amongst the parties, or is it driven by a particular judge managing a matter, or a combination?
A combination of those things. I think we do need to see more cooperation. We see a lot more cooperation in the alternative dispute resolution space, so international arbitration. I think there's an education piece across the industry, right? From the judges down, all the way down to the junior lawyers, the paralegals, the students, particularly the bar as well. And I just think it's a legacy issue that we have, that the standards and the way things have been done have been in place for a long, long time. Technology has changed, the type of information has changed, our capability has changed, and the process just hasn't kept pace. So the legal industry is not one for changing too quickly, and I think we need to sort of drive that change a little bit more and change that culture.
Thank you.
An oft-cited fear is it will cost a lot to enact these changes. We'll need to hire someone like you and your team. Can you talk a little bit to the capital expenditure required to go through these changes, if any?
Sorry, Prashant?
The capital expenditure required to go through these changes or enact these changes, if at all?
There certainly is. There's expenditure around the change management piece and the education piece. I don't think you need additional people. I think what you need to do is change the habits and the processes of the people that already exist within the industry.
Thank you, Jonathan. One of the things that I guess picked up my interest was when you said you want to avoid double handling. If you uniquely number a document once, do it uniquely, do it once. Yeah. And I'm very interested to hear from you, I guess just a comment or an observation in terms of how metadata plays a role and our lack of understanding of we used to, I guess a document used to have a title, it's got a date, when it was created, and now has a unique number. And I think in the digital world, most practitioners are actually not quite understanding the value of that metadata. Yeah. And it can be sorted in so many ways. If I could just have a comment or an observation in terms of not the document, the content, but the data behind that actually labels that document.
Yeah. I think it's a good point. I mean, metadata is by definition data about data. And the way that things have been done in the past is to try and incorporate metadata. So, for example, the exhibit reference on a document is included in the number that's stamped on the face of it. It might be exhibit JP1, and that indicates that it's my first exhibit. That's no longer necessary because we have this capability of capturing, recording, and using metadata. You no longer have to try and do that. The metadata can be captured in the databases, in the systems, and the document can just exist on its own without needing to be altered or amended or duplicated in any sort of way.
And is it the lack of the visibility of that metadata that is, I guess, the most difficult, or the biggest reason why there's resistance to understanding and using and implementing this system?
I think it's a lack of understanding about the capability, what you can do with metadata and how it can be used in a relational sort of database or a relational data kind of world. So again, there's an education piece. We often find when we're preparing for a matter, or we're talking to council, or even preparing for a court book, there's a discussion around, okay, well, what numbering system should we employ? And they try and incorporate information about a numbering system, about the document, into the numbering system. So, for example, a while ago, we were working on a matter, and council said, okay, let's have D for all the defendant's documents and P for all the plaintiff's documents. And then the obvious question is, well, what if both parties want the same document? So it's unnecessary to incorporate that sort of information into a numbering system. It can be captured separately and related to the document. So there's an education piece there, I think.